Great. Welcome again to everyone who's just joining. I'm admitting a couple more people from the waiting room. I forgot to press record at the first instance, so I began by introducing Elizabeth Stein, Monica Miller, members of our legal team who have been here from the beginning. We're here to talk about important May anniversaries in the history of the non-human rights movement and the NhRP. So I was talking about Hercules and Leo, two of our first clients who were used in research at Stony Brook University. They were held in a basement lab, didn't see sunlight to our knowledge for years, taken from their mothers, all of that awful stuff. And so they, in the spring of 2015, became the first non-human animals to be granted an order to show, what's called an order to show cause pursuant to a writ of habeas corpus. So what I'm going to ask the lawyers to do is explain to everyone what that means from a legal point of view and why it was so important and what made it a first in legal history, not just in New York and in our work, but around the world. Yeah, so Lydia or Monica, whoever wants to start.
Lud?
You wanted we're both too polite. Go ahead, sweetheart.
Well, the order to show cause is the same thing, just from a technical standpoint, as issuing the writ. In various states, they sort of denominate them either saying the writ of habeas corpus, which we know is the ancient writ that is used to release someone from prison, from an imprisonment. An order to show cause just means that you don't need to produce the person in court, and that's usually for practical reasons or for safety. So in our case, we weren't asking them to literally bring the body. The corpus means the body. So anciently, like, you would bring the body into court and you would decide whether they were being unlawfully detained. With children and other people that it would be dangerous or difficult to bring in, it's an order to show cause. But from a technical standpoint, we wanted to make sure we got that right when we announced it.
Mm-hmm.
Right. And what's to add on what Monica is saying and kind of address what another part of what Lauren was asking, why this is so historic is because, what habeas corpus is looking at is this right to bodily liberty, because it's, as Monica said, it's the most ancient writ that goes to addressing whether somebody's liberty is being violated, whether the detention, imprisonment, captivity, however you want to call it, is lawful or unlawful. And it's saying to the captor, you have to come forward and explain the legality of the detention. What's incredible in our work and from our perspective is we all know, if you're on this call, I'm sure non-human animals have no rights, particularly the right to bodily liberty, which is fundamental to all of us. And what happened with the issuance of this order to show cause was Justice Jaffe in New York Supreme Court was saying, you know what, we need to hear this case. Yes, it might be about a non-human animal. Yes, we understand that these chimpanzees don't right now have the right to bodily liberty. We haven't recognized this right, but it's essential. This case is of such utmost importance that the Attorney General of the state of New York, who represented Stony Brook, because Stony Brook is a state institution, had to come forward and come to court as they would have to for a human being. So this is the first time that, as Lauren said, an order to show cause, the writ of habeas corpus, was issued on behalf of a non-human animal. In this case, it was Hercules and Leo, two chimpanzees. And I don't know who in our audience saw Unlocking the Cage, which basically was the documentary that chronicled our chimpanzee cases. D.A. Pennybaker and Chris Hedges just made the most extraordinary film. But when the order to show cause was issued, they got me on film saying, do you think this judge, I didn't even know, I don't think I knew her name at the time, Justice Jaffe, do you think Justice Jaffe knows what she's doing? And she did know what she was doing. She absolutely did. It was not a fluke. It wasn't a mistake. She wanted this case heard. And then I'm going to stop talking, Lauren, but Hercules and Leo for me was such an important case, because I know we talk about the Court of Appeals, we talk about Judge Fahey, and I know we're going to get into that a lot today during this hour, but I don't think we speak enough about Justice Jaffe.
Yeah.
Because but for her, I don't think any of this would have happened. And you know, her courage in being the first judge to ever do this was extraordinary.
And just to really echo, I mean, Liddy's giving me just goosebumps because it's bringing me back to that court hearing when she says, you know, isn't it incumbent, you know, kind of, she recognizes her role as a judge. She's not saying they are going to be set free today. She probably knows in the back of her head, she's unable to legally, I mean, given her role as a trial court judge, but she is aware of the burdens of proof in a court of law. And she felt that we satisfied that burden of proof to get an animal free. And that was so monumental that, you know, she came to the court prepared with all sorts of, you know, like beautiful quotes and, you know, what she was saying. So it wasn't, like Liddy was saying, it wasn't a fluke. And it wasn't just, oh, you know, Joe Schmo come to court. We had filed previous petitions on behalf of Tommy, let's say, and he was in an upstate trailer. That would have just been one private individual. She was requiring the state of New York. We had a state attorney on the other side of the podium. They were so underprepared because they didn't know, you know, that this would be taken so seriously. And it was kind of, frankly, an embarrassment, I think, for the state, because they didn't know she was going to take us so seriously. And I think the way she took us seriously really reverberated back into the media. And like Liddy said, we might not be here with the Fahey decision and the happy sort of progress that we have if it weren't for Judge Barbara Jaffe.
Yes. And one thing I would also like to add, and this is not to pat any of the NhRP lawyers on the back, but I'm going to, is because what happened here shows how we will never leave any stone unturned. Because with Hercules and Leo, as Lauren said, they were in Suffolk County, they were in Stony Brook at that facility. We lost. We brought the initial petition there. Again, if you see the film, you see Stephen Wise and I sitting outside the courtroom waiting for the judge to rule. Within a very short amount of time, we get this single piece of paper basically saying denied. So what could have happened at that point is it would have been denied and that would have been the end of it. But we all congregated and said, okay, we need to keep on thinking outside the box. What can we possibly do to move this case someplace else? And we did, and we studied and researched, and we were very sure that we were correct, that we could bring this case somewhere else. And that's when we filed the same case on behalf of the same chimpanzees in a court where they were not located. And
it was a stretch. It was such a stretch.
But
it was exactly.
Stretch, but we felt that legally we were correct.
We were.
And finally, there was a judge who recognized the fact that, yes, legally they are correct. The rule permits them to do this. I want to hear the case. We're going to hear the case.
Yeah. And that is super significant, because ordinarily outside of habeas corpus, A, you can't refile your case after you lose, and B, you're normally confined to a jurisdiction within a state, you know, a venue. But because of our extensive research, we felt that even though there weren't very many cases, what's significant about this is we were able to use the law in such a beautiful way, even procedurally, that we had spent years even prior to this case researching whether you could refile a case when you lose, because we knocked out states. We're like, we are not going to file in a state if we don't get a second chance, because we know this is common law and it's going to take a while for it to percolate through the courts for them to get this. So we deliberately picked a state that allowed us to do this. Then we picked a state that within the state we could pick what, you know, jurisdiction we wanted to be in. And that wasn't really easy, because without a lot of cases, you know, either cases fall into child custody or prisoner or this. And so it's really hard for us to sometimes suss out where a court will see us falling into in a sort of scheme. And we really were able to use the law to advance, you know, rights for animals, even just on a procedural level.
Yes, thank you. you guys already answered several questions. Thank you for anticipating those. I was going to ask if you could speak a little bit more to sort of this idea of what we expect going in, and that is driven in part by, like you said, our years of research and preparation, and then what we can be surprised by. My question really there is with Hercules and Leo, with Justice Jaffe granting that order really so early on. Like, animals have been legal things with no rights for centuries, like just de facto legal things. There's no consideration of them being anything else unless they're put on trial, like in medieval times for, a crime, quote unquote. But yeah, to what extent were you surprised by that, at least at that juncture in what we were doing? And if so, like, why?
I was shocked. I'm still shocked that it happened, and I am always just shocked and, of course, in awe of how far we've come in this 10-year period. But I think, Lauren, to answer your question, why was I surprised? I was surprised because, number one, I think, as Monica said, trial judges are very limited in terms of what they can do.
Oh, and one moment, could you also explain what a trial judge is?
Yes. So when you file this case, and in New York, the court system is very wacky in terms of the names of the courts. So the lowest court is actually called the Supreme Court, as opposed to most states. The most important, the highest court is the Supreme Court in the United States. The highest court is the Supreme Court. In New York, the lowest court is the Supreme Court. Then you move up to the appellate court. The highest court is the Court of Appeals. So your ultimate goal, and our ultimate goal, because when you're trying to change the law, the status quo, as we are attempting to do with having a court recognize a right on behalf of a non-human animal and changing that status quo from thing to legal person, that ultimately it has to be the highest court that does it. But in New York, you have to start at the lowest court. So you file your petition at what's called the trial level. Even though a trial is not going to happen, we didn't bring in witnesses. I mean, we could have, but right. the expert opinions that we filed spoke for themselves. So we didn't actually have to bring in human witnesses. So at the trial level, at this initial court level of where you filed the petition, it's very unlikely that much of anything is going to happen. So the fact that this order to show cause was issued was very unexpected, because it's hard to think that a judge, for the first time in history, because this has never happened before, would have, as Justice Jaffe did, the courage to do it. It's great because the ice has been broken. I don't know if the glass ceiling kind of applies to this, but it's not as scary anymore for a judge to do that.
Exactly.
And that's what's so important in any kind of movement, a civil rights movement, whatever movement, where you're changing the status quo of something. You have to have one judge with the courage to do it initially, and then that opens the door for other judges. And that's what happened then with Happy. We had the order to show cause issued on her behalf, and we're hoping now, going into other states, that we can say to judges, don't worry about it. You're not an outlier here if you did it. It happened in New York. It happened twice. Chimpanzees and an elephant. It ultimately went to the highest court in the state of New York. So don't be afraid anymore.
I love that. Monica, did you want to add anything there? I've got
Yeah,
more.
I mean, not really. I feel like I was also surprised that it happened as fast as it did. I mean, I was really, I was in this for the long haul. I went to law school to do animal rights, to get animals' rights. Like I wasn't, like my expectation with the common law and watching how other civil rights movements have worked, they don't happen overnight. And this is a gradual process. Everything you read about the common law, it's like this slow accretion, case by case. And that's what we buckled down to do. And so we got a few losses at the outset. We were like, those are expected. And I kind of felt like this was, especially because it was a long shot in the sense we were going into the city of New York. We were going into a place where a lot of human cases were high profile, and a chimpanzee case couldn't possibly be high profile with those other ones. Whereas if we filed up in a rural part of the state, which we did initially, we thought they'd have more time on their hands and they could sink their teeth into this. And that was not true. And then, just to see the courthouse get flooded with people, I mean, that was the speed in which we were able to go from 2013 to 2015 and getting that petition issued, or the writ or order to show cause issued, that to me felt like we're on the fast track to something.
Yeah, absolutely. And I remember us all convening in an email probably, and then on a call, but just we were so excited for our clients to be able to argue for them, like have them get their day in court.
Right. And if I could just say one other thing, Lauren, because I think this might draw the distinction. The first case that we filed was Tommy. And that was, in, I guess, mid New York, right outside of Albany. And the judge who heard the case was very, very sympathetic. And he actually, to our utmost surprise, held, it wasn't oral argument, but he wanted to hear from us. He wanted to hear what this case was about. He was fascinated by it. And basically, although he denied the issuance of the writ or the order to show cause, he kind of set us up for being able to, and I mean, set us up in a very good way, to be able to appeal the case.
Yes, that's right.
And he wished us the best of luck.
Yes,
which we thought at the time was the greatest thing that could have happened. Just getting a judge
to
listen to us. This is our first petition. He's hearing us. He's really fascinated. And then he comes out and says, you guys are doing something so important. I love animals. Keep doing it. I just can't do it. And that's, so that was that's the expectation going in. Hopefully you get a judge who's sympathetic. And then but felt he couldn't do it. But then we got the judge who was sympathetic and felt she could do it and did.
Yeah, absolutely. And on that note, actually, we can transition now. There's so much more to say about Hercules and Leo, and I see some people in the chat asking about where they are now, and we'll get to that towards the end. But if we could transition now to 2018, I think it was May 8th, when New York Court of Appeals Judge Eugene Fahey issued an opinion in our chimpanzee rights cases on behalf of Tommy and Kiko. Tommy was living at that time in a shed on a trailer lot. I'm sure many have seen the photos of him in that green steel cage with a TV for company, which his owner thinks was great enough. And then Kiko was living in a private home, spending a lot of his time with a chain and padlock around his neck, which the owners used as like a leash, just heartbreaking. And so we had filed a second round of petitions on behalf of Tommy and Kiko after I hope I'm getting this right to the lawyers, but the New York's top court had denied us once, said, no, we're not going to hear the case. So we tried again, because that's what we do.
Exactly.
Yeah, we do not. And so, and it paid off in a really massive way. And so, because along the way, the appellate courts, which are the mid-level courts where they're still working through the issues, the novel legal issues, but then the top court gets final say. And the appellate courts have said some really wildly wrong things over the years. And we can talk a little bit about them, like what they've gotten wrong. And then that's what sort of binds the lower trial court judges too, in other ways. But so anyway, Judge Fahey, when the case came to him, the rest of the judges said, we're not going to take this case yet again because they filed a second petition and we think they can't do that. We maintain still that we can, and I'm sure we'll do it again at some point. But Fahey said, like, okay, I get that part of it, but I have much more to say about it. and he took the opportunity to write. Is it that he was the first judge to issue an opinion like that, to disagree? Can you guys talk about what made it a first, like just in and of itself, and then the content, like what did he say and why was it so important, and how did it build on what Justice Jaffe did?
I'll take the procedural part, being the New York lawyer here. So, and then Mana, I want you to go on to, the import of this decision. So, just, and I don't think it's too much in the weeds, because I think it helps understand what exactly
into the
happened.
procedure.
Right. You can't, to get to the Court of Appeals, you just don't go from the trial court to the appellate court to the Court of Appeals. The Court of Appeals has to accept your case. And unless there are very narrow instances in which, if there's a constitutional issue, that the Court of Appeals must hear your case. But for most cases, the Court of Appeals picks and choose. What you do as a lawyer is you file what's called a motion for leave to appeal. So we did that the first time we did it, and it was denied. We did it a second time, it was denied. And then we did it the third time on behalf of Tommy and Kiko together, after we had filed for them a second time for them in New York. And on that motion for leave to appeal, although again, it was denied, that's when Judge Fahey wrote this unbelievable concurrence. As Lauren said, he agreed with the procedural aspect of it, but said, no, guys, I have to get to the merits of this case, because this is the third time that it's come across our desks. And, when you read the decision, that he basically comes out and said, I might have been wrong those other two times.
Yep.
This is the time that we have to really talk about it wasn't the elephant in the room at that time. It became the elephant in the room. It was the chimpanzees in the room. That this is an issue of such magnitude and such gravity that it's simply unjust not to hear it. So there are several first.
Oh, sorry. When you say it is an issue of such magnitude, what is the it there?
The it being the recognition of these, in this case, chimpanzees, the fundamental right to bodily liberty protected by habeas corpus. That is the it. That's what we are in every petition. That's what we are asking the court to do. We're asking the court to recognize this very specific, narrow right, no other rights. Once they recognize the right, understand that clearly the imprisonment is violating the right, and then the ultimate remedy in habeas corpus is the release from that particular imprisonment. So what Judge Fahey did was, for the first time, he wrote an opinion on a motion for leave to appeal. That doesn't happen. It's granted, denied. And it very, very, very few cases, I don't know, maybe Monica, you know the percentage, or Lauren, you do, but of the cases that are filed, the motions that are filed, the number of cases that are actually heard by the Court of Appeals is very, very small.
Yeah, it was like 5% or something like that.
Exactly.
And no one concurs from a denial. Like, these are unheard of. I mean, like, that was like, I think he talks about, sorry to cut you off, but I think he even talks about it in some form or fashion. I think we come to learn that, like, he was maybe the only person that had done this in recent history, in like the history that they could track, because they usually try to agree. They really try to be unanimous, unlike the US Supreme Court. It operates quite differently.
Right. And what he was concurring on the procedural issue, and he made that clear. But then he said, he said, this is not the denial of this motion for leave, because that's not when we were heard. He said, I still have to deny the motion because of this procedural issue. However, and I always felt that he was doing this as a wink, wink, nod, nod.
To come back.
File another case.
Yeah.
Because if
for
you
sure.
file another case, it is ultimately, if I have anything to do with it, it is going to get to the Court of Appeals. And I'm just going to read one thing if
please
I
do.
can, because
I was going to
when-
try to pull it up, but I couldn't find it.
yeah. No, Lauren, as you suggested, I did go back to his concurrence, which I know Monica and Lauren, I'm sure you as well, we've read at least
So many
100 times.
times.
And every time you read it, something else is so striking. But I never really focused on his first sentence, which is the inadequacy of the law as a vehicle to address some of our most difficult ethical dilemmas is on display in this matter. That says it all. It's like, here he is. He's recognizing the fact that the law is inadequate to protect these animals. We need to address it morally, ethically, as a matter of justice. So, Monica, I'll let you take it from there.
Yeah, I mean, I think you really covered all the sort of parameters. I mean, the import of the decision is simply that he did really give us that confidence to come back. I mean, if we had just lost after Jaffe kind of getting up there and they just said no, we would have probably wanted to stay in another state and not come back. But the way he wrote this, it was like, why would we leave? Like, he just said, I think that the court should reevaluate this. And it gave us a lot of hope, and it kind of paved the way for Happy's case. I mean, it did pave the way, not only because of what he said in terms of come back, but because of what he actually wrote in that concurrence. I mean, it is stuff now we can cite, and that's really how the common law develops often, is usually one judge dissents or a lone trial court has a decision. And if that's correct as a matter of morality and justice and all of the other variables that the common law must take into account, then that is the progress of the law. And so it's usually the dissents become the majority eventually. And so it really was kind of the formation of the law itself when he wrote that concurrence that is now quoted extensively, not only in our briefs, but it was integrated into the two dissents, that the historic dissents that we got in the Happy case. And sort of as a segue, kind of before we get into that too with Fahey, was that his concurrence, like just like Jaffe's order to show cause was a first of its kind, Fahey's concurrence, just branching out of what the deviation from the normal practice to do that, was kind of the first of its kind. And then when we jump over to the dissents, just to put these all together, this was the first time ever that I think they were like the longest dissents in New York Court of Appeals history. Like Judge Wilson, I think, wrote the longest dissent ever. So these were things independently and outside of what we were doing, we're creating history in these kind of other interesting ways, which Judge Wilson ended up becoming, I don't know if this is like a spoiler alert, but was appointed the chief judge, the highest sort of position on the Court of Appeals because of our case. So and he's now the first African-American Court of Appeals judge in New York. So we really have made history in all these kind of like sideways. And I'm not saying this to like brag, but just because it's not the speed at which we're accomplishing this stuff is still impressive to me from what my experiences were.
Right. And totally, Monica. And just, again, this is not a spoiler alert. I'm sure everybody knows that, Happy's case was heard by the Court of Appeals. And Monica's talking about the historic dissents that we got. And this was the first time that the highest court of an English-speaking jurisdiction heard an animal rights case. So
Happy.
It's
Yeah,
the first, and we have a lot of incredible firsts, I believe, within a very, very small amount of time, which is what gives me such great hope that, and as Monica said, and I love that she said this, the dissents become the majority. And that's what you have to, when you think about, winning, losing, did you win this, did you lose that? That's not the paradigm you use in a movement. When you're changing the status quo, you're looking at the long game, you're looking at the big picture, you're looking at whose minds are you changing? And especially in animal rights, where it's something that very few people have understood, even people within the movement. And it's understandable because animal welfare, animal rights, it can be very confusing. Is there crossover? Why is one important? Why is the other important? So you can only imagine for judges to now kind of wrap their head around something that in all likelihood, they have never even thought about. So, you're getting judges to now listen to you, to understand the issues, which clearly, by round 3, Judge Fahey did. And that's what he was saying. It takes time, but just getting to the Court of Appeals was, on behalf of Happy, a huge victory for non-human animals and for the movement.
Right, because the courtroom doors can be shut much earlier.
Yes, as they have been for us.
I don't want to bring that up, but yeah, I was going to say
Right.
it could go a different way, and we really.
Right. And I know that in Judge Fahey's opinion too, he expresses, I don't know if he uses this word, but regret about not having considered it deeply enough the first time, which is really powerful.
Oh yeah.
Yeah.
Because he's saying he's changed. We have changed his mind, is what he's saying.
Right.
We're not going. This isn't, to be political. This isn't some like liberal snowflake judge. This is just a judge. He's known as almost maybe even leans conservative, if anything. I mean, and he's saying, I thought one thing, I've thought about it more, and now my opinion has changed. And that's our goal. It's not to just preach to the choir. It's to convince judges that their law needs to change.
Right.
And that's why we're so careful about what we say and how we frame our arguments, because we understand going in that it's very difficult to change the mind of a judge. And so
incredibly.
How do you do it? How do you make an argument that's really going to change things dramatically? How do you make it palatable and easy and understandable? So, it's a balancing act, I think.
Yeah, and we're making up the law. I mean, we have to come up with the analysis. There is no analysis for a common law, how to become to get a right for habeas corpus. I mean, we have to collect all the law and show the judges in a coherent fashion within the word limit, like why we should win. And so it felt very good to see Judge Fahey say that you guys did that. Right.
And to really appreciate our arguments and basically, agree with them. Say, yes, this is how one should analyze a case, a rights case on behalf of a non-human animal. What you do not do is say the animal should not have a right because the animal is not a human being and only human beings should have rights. You don't do that. You look at the intrinsic nature of this non-human animal, which is what he did. In that case, it was chimpanzees. And I believe he really studied what we presented, the unrebutted expert testimony from the most renowned primatologists, who basically lay out the autonomy and extraordinary cognitive complexity of chimpanzees. And that's what Judge Fahey understood. He understood that these chimpanzees plan the way we do. They suffer the way we do. They understand the past the way we do. If they're in prison, they understand that their future is in prison. Why should they be denied a right that we have?
Right. Yes, absolutely. See, you almost made me tear up there, Liddy. Okay, thank you. We're going to move on actually a bit. There's more to say on that too, but to Happy's hearing in the Court of Appeals, which was a year ago this month. And Monica argued that case, which was so exciting to see. And here's what we're going to do on this. This will be hard perhaps, but we're going to limit the discussion to the hearing itself. Like, it yielded 2 massive dissents, which a couple months later, but to really emphasize how important it is just to get a hearing, no matter what happens. We're not going to talk about the dissents.
Yeah.
So we'll talk about them in a couple months. We'll probably have another Zoom just on them. But
So we expect everybody to come back.
yes, please. So we're going to very quickly talk about that hearing and what made the hearing itself so massive, just getting in the door. And then we're going to open it up to questions. And I see lots of them coming in the chat. So there might be more than we can get to, and we'll try to address them later if we don't get to everybody.
Yeah, we could do a Zoom part 2.
Yes, right. So, and Monica, maybe you could start by talking about what it was like for you that day, and like what stood out to you about the hearing, like what seemed most striking to you about that, what happened in the room that day.
Gosh, I mean, it feels like in some ways just like yesterday. I mean, it was so exhilarating because, again, being there with Liddy, it felt very full circle that we had, been together since we filed this, when I was in law school, writing the research memos. We were discussing these such conceptual ideas. And then all of a sudden we're in court together, and, I'm about to go up there, and I had kind of a calm feeling because we were so prepared, and out the gate, I guess I could say I was a little, I wouldn't say surprised, because I prepped by watching, because luckily the Court of Appeals post their arguments on YouTube. I've argued in the US Supreme Court where they don't even, like, you get an audio recording only. So I was able to watch these judges and how they interact. And Judge Jenny Rivera had been on a TV screen this whole time because she was, I think, for a while unvaccinated. And so I noticed in a lot of the oral arguments, she kind of was a little bit like loud and asked questions right away out the gate, and kind of like usually like kind of hostile to the other side. And so she was the first person to ask me a question out the gate, and she was kind of like, I'm over here on the screen. So I was braced. I was a little braced for that, where other people weren't, because I got a lot of questions from reporters that were like, did you think she was like, her question was harsh to you? And I knew even before we got the rulings that it wasn't harsh. And her question was something like, well, what about dogs? I think that was maybe her first question out the gate, but it was something that was, or maybe it was like, how do you define autonomy? But it was something that let me know that she wanted me to answer the heart of what the judges that would be against us were concerned with. And that's what a good oral argument indicates, is that they're almost playing devil's advocate. Like when a judge is on your side, they want to ask you the tough questions. I'm going to get some softballs from these other judges because they're already like, I'm not going to rule in her favor. So they'll just give me something for show. But she was like, tell them this. And so, I think that was, the feeling was excitement, and like feeling that we were, knowing that we had all of these supporters outside on our side, having Steve with us in the lawyer room, we had enough time to just like hang out and not just be stressed out about it. So it felt like we were really there to do what we set out to do.
And I'll just add too, because I was sitting out with supporters, which was so fun, because usually I'm emailing people, and just meeting people is great. So thanks for everyone who joined us that day. But we were watching outside on a screen, and when Judge Rivera asked the other side, and I realized we didn't say who the client was as clearly as we could, but happy and relevant, held alone in captivity in the Bronx Zoo, and we'll talk about her situation more later. But so she asked the lawyers for the Bronx Zoo, like, isn't a gilded cage still a cage? And there were gasps in the audience. Like, people were so moved and struck by that she said that to them, like brought that hostility to them. But I'm in a different way. I just remember that. I'll remember that moment forever. Just everyone was like, wow, like she said that.
And she, exactly.
Challenge that status quo, because the Bronx Zoo enjoys this reputation as like, do-gooder, but meanwhile they're creating tremendous suffering for elephants and other animals, every day. So
I would say the other surprise that I had was, and this is relevant to anyone on here that has, is a dedicated animal rights person and is familiar with Peter Singer, but I should back up in saying that one of the beautiful things about Happy's case and just being there and getting to the Court of Appeals was all of the amicus brief, the friend of the court briefs that were behind us and backing us up. They were hailing, like, all of the good guys were on our side. Like, there was like trade industries on the other side, and like the dairy industry, and we had moral philosophers and like religious, like theologists, and from all the whole like religious spectrum, like Buddhists, Catholics, like Jewish theologians, like everyone was there, and all on the side of Happy. And so inclusive of like Peter Singer, and who was someone that, you know, in high school I was quoting from. Like I didn't even know probably that he would still be alive by the time that I'm here now, just because of how young people think when someone's quoted in a book. But he to me is like the pinnacle of rights. And so when Judge Wilson had asked me a question later into the argument about Peter Singer's amicus brief, I had this kind of moment of like surrealness in a way. Like, how am I in a case where I'm arguing this case and we're talking about Peter Singer? And then it also was cool to me that there was a judge on this court that took the time to know who filed amicus briefs, who knows who Peter Singer is. He was kind of like, the way we were dialoguing about that just felt very like historic kind of in its own right. And that we had judges that really, both Rivera and really all the judges, came prepared. And I think I was asked questions by every single judge, which is also quite rare, because usually there's a couple judges asking questions, some are checked out. This was a very engaged panel, and I felt like even the judges that that were not on our side, even their questions carried a more serious tone than we've had in the past. Like in the first department, we had judges that kind of mocked us. Like this one was like, what, like lions and tigers and bears? Like she just had this attitude that was like, you guys are so like dumb. And like, so even for the chief judge, who at the time was very concerned with the dairy industry and made that known in her questions, she was still very like polite and respectful and felt that we deserved to be there. I got that sense. So that was sort of the impression of the room that I had.
Mm-hmm. And would you guys say that the judges on the whole, not that we can read their minds, but all along the way seem sympathetic to the plight of the client? Like they might be hesitant to release them for various reasons, but it seems like
well, yeah. I mean, I said yeah, kind of excitedly, and then I'm thinking, no,
I'm not so sure.
I think that there were some judges that could have been persuaded if they understood the situation better. I think we would not have been able to persuade the chief judge.
Nor do I.
She was very concerned with like the trade industries and not impacting anything, which we were like, there's no impact. Like you free Happy, there's still cows. Like there's no one's, our hands are so tied right now that we can't even free the most, like, I wouldn't say Happy, there's many deserving clients, but a lone elephant with the world-renowned scientists all in accord, world-renowned philosophers, religions, everyone on our side that matters, judges, like it, like there was no convincing this person.
Yeah.
I agree, Monica, totally. And if I could just add one thing that I think we also sometimes lose track of is that Judge Fahey was not on the bench because there is a mandatory retirement age, right, and he retired prior to Happy's case being heard. So there is a very, very good chance that had he been sitting on the bench, we would have had 3 dissents, or perhaps Judge Fahey might have been able to convince somebody else who was not going to, who did not rule in our favor, who was part of the majority. So it was really bad luck and timing for us that the case was heard after Judge Fahey's retirement. But again, he got us there. So, and we did have these 2 incredible dissents. And I'm just, you know, again, going back to your question, Lauren, I'm not sure that every judge recognized the extent of Happy's plight at the Bronx Zoo. I think there could still be, and I can't read anybody's mind. We haven't spoken to these judges. I have no idea. But, you know, there are probably still individuals who think that Happy is perfectly fine where she is, that she's being fed, she's being taken care of, notwithstanding the fact, as Monica said, we have, you know, affidavits from the greatest elephant experts in the world, none of whom had been rebutted by any expert from the Wildlife Conservation Society, all attesting to the fact that Happy should not be there, that she is suffering in her captivity. Mm-hmm. So, you know, I think sometimes you might have to accept the fact that you're not going to convince everybody, but you don't have to convince everybody. If you convince the majority, you're going to get where you need to be.
Right. Thank you. So I didn't leave too much time for questions. We're going to squeeze in as many as we can. And Monica, are you by chance able to stay on a little longer? Or
Yeah.
just a little bit? Lydia, you might have to go, but you're welcome to stay a bit longer too for questions. But if you have to
Sure.
hop off it, you know, at 12, that's okay. The first question comes from Maureen, who's a New Yorker. She asked about happy what now. She says she's a born New Yorker. She's rarely ashamed of her city, but she is about this, and she's made her feelings known to the Bronx Zoo, I think, multiple times. So, and I'm going to add a question to that I see also in the chat. So what's next for happy is we and this spring, a New York City Council member, Shahana Hanif, with our support and assistance in the development of it, introduced what could become the first elephant captivity ban in the US. And we're at the point where now that the court has said no, they're not going to release Happy, we think this piece of the legislation is the best and quickest way to get Happy and Patty, who's the other elephant held alone in the zoo, out of there into a sanctuary. So that's a whole nother discussion, but like that's what's next on that level. And the other question though has to do with the interplay between litigation and legislation. How you guys might, we don't have our director of government relations on today, but like if there's anything you guys want to say about how they work together.
I feel like we're both a little bit like, I mean, you can speak to it, like I feel like they kind of hold separate places in my head, but
yeah, which is fine. You say
yeah,
more.
and I agree, Monica. I think because it at times has been problematic for us, because one of the issues that we always have to address in our habeas corpus litigation is, why isn't this a matter for the legislature? Why should we as the judiciary be deciding this when this should go to the legislature? So it's a problem that we face, that we have to explain to the court. No, this is a common law case. The legislature and the judiciary can run on parallel tracks. So just because something might be decided by the legislature does not preclude the judiciary from doing it. And I think that Judge Wilson recognized the fact, I think it was Judge Wilson and not Judge Rivera, or perhaps they both spoke to the fact that they would be remiss in their judicial obligations if they did not hear this case, because this is, as a common law case, this is why they sit as judges, especially in New York, that is well renowned in terms of the judiciary as being a common law state that tries to really evolve the law to reflect changes in society, in science, in humanity, in ethics, in justice. So, I think that you can do both. One is not to the exclusion of the other, but I think, sometimes it's easy. It gives judges a very easy out to say, we should not be hearing this case because it's a matter for the legislature, but that's simply untrue. So, we had Happy's litigation. I know during the course of the litigation, the legislation wasn't even being considered. It wasn't until the Court of Appeals issued its ruling that, it really started to gear up. And if we can get Happy and Patty out of their captivity because of this bill, it would just be fantastic. Absolutely fantastic.
Right. We'd also celebrate if the Bronx Zoo decided to on their own to release them, but that doesn't seem
absolutely
to happen. So yeah, thank you. I'll move on to the next question, which comes from Noel Sweeney, who's a barrister. That's the same word for a lawyer, right? In the UK, is that right? Okay. In New York, in the UK, he's written a lot about the status of bees under the law, which is he does very interesting work. But his question pertains to essentially to why legal personhood. Like he was thinking about the term legal personality as distinct from that somewhat, but thinking about how a judge could have an instinctual negative reaction to like an animal is a legal person instead of that they have legal personality. It sounds a little less scary maybe. So I just wondered, the broader question that I would like you to answer is, why legal personhood?
I can answer that. It's not really that that's what we're seeking. We're seeking a right. And the consequence of having a legal right is personhood for the purpose of that right. So it's not what we've made up. It's like, that's just what happens. And I think at the beginning of our cases, we focused a lot on that because that's just how, you know, lawyers would talk about having a right. So when corporate personhood doesn't mean the corporation is like a human, it means that it has the right, a right for a certain purpose. Corporations don't have the right to habeas corpus. They have First Amendment rights, but we're seeking not First Amendment rights, but just the sole right to bodily liberty. So if Happy were to win, she would have the right to bodily liberty under the common law, but that doesn't give her any other, necessarily give her other rights, like any constitutional rights. You know, we don't know what other rights could come with that, but it wouldn't be, it would not be like the whole panoply of rights, if that makes sense. So, you know, I think in some ways we might even be trying to veer away from it a little bit more just to avoid confusion, but it's really just a legal term of art, and it just means that you have a right.
Right. I think the other reason that this became an issue is because, for example, in New York, if you look at the procedural statute, it uses the term person. So when we first started, our inclination was, well, if it uses the term person, we have to explain why our clients are persons for purposes of the statute, because, you know, a judge is going to say,
We were worried they were, yeah, we got ahead of ourselves. We were trying to anticipate an argument that in so doing, we like drew attention to that.
Right. Well, yeah, I think kind of yes and no, because when, for example, with Hercules and Leo, at the first case that we filed in Suffolk County, what we got back was they're not persons for purposes of CPLR, you know, 70, blah, 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 blah. So, you know, we were correct in that that this term was going to, you know, kind of ring bells and flags were going to go up. But what we've done in our evolution is we're trying to take the court away from looking at this term. And as Monica said, because it's really just a term of art, that if you recognize the right, you are a legal person, you will be a legal person for purposes of that habeas corpus statute. And that's what Judge Fahey was saying in his concurring opinion. He was saying, stop worrying about who is a person. That's not the issue. That's not the issue that should be before the court. It should be, what is the intrinsic nature of the non-human animal, and should the right be recognized?
Thank you both. Yes. Okay. And you, just to confirm, you can stay on for a little bit? Both
probably just like not too much over, but
10 minutes?
Yeah, like 10 minutes?
Yeah. Okay. We'll pack a lot in 10 minutes. We'll do more of these everyone too. So
yeah.
Okay, cool. And people are you know, asking about Minnie, our client Minnie in Connecticut, Minnie the elephant, and that was our first elephant rights case. People are deeply invested in her plight. I mean, obviously, and she's used was used in a traveling circus that used bull hook, and there are 2 other elephants who died, and just yeah, heartbreaking, unjust. But the question is, these victory or these moments we're highlighting, why aren't any of them in Connecticut? What's your read on that? What's the big difference there between New York and Connecticut, where in New York there's such receptivity on the whole, changed minds and all this? Like, what's the difference, do you think?
I don't know. I still have PTSD from Connecticut.
We didn't like Connecticut. It was like we didn't get the Fahey invite in Connecticut.
They just, you know, I guess these things happen, you know, and it's almost to the question you were asking earlier, Lauren, you know, do you think the other judges on Happy's panel really did feel that she shouldn't be where she is? These judges wanted no part of us. You know, we thought the law in Connecticut was on our side, which we were correct about that. I mean, it is, it was, it is, it continues to be. just notwithstanding the way these judges ruled, and they just didn't want to hear our case.
Yeah, they definitely want to maintain the status quo.
Very much so. And
Yeah.
it's a very sad status quo
I
that
agree.
they want to maintain.
And there's still activists fighting in Connecticut in the area for the Cumberland Zoo animals. So that the fight continues, as with any of our clients, the fight always continues beyond the courtroom.
Behind the scenes.
Yeah, there's much behind the scenes, and then actions people can take. We won't be getting to that all really on this call, but yeah, we just want everyone to know that. Oh, my dog's gonna bark in 1 sec because there's a delivery. So I'll mute myself. But okay, thank you. Another question comes from Richard K. I think it's a powerful one. It's a hard one that I'm adding here at the end for you guys. But he saw a headline on CNN. It was nearly half the world's species are seeing rapid population declines, a new study finds. And then a subheading on that was global loss of wildlife is significantly more alarming than previously thought. And the question is, how do you see ever affecting enough change to affect that? Again, it's a hard one.
Yeah.
I'm sorry, could you repeat the question, Lauren? I didn't understand it.
Yeah, it had to do with a headline that came out. I think,
Yes.
About
Habitat loss, or like
yeah, rapid. Nearly half the world's species are seeing rapid population decline.
Right.
And the global loss of wildlife is significantly more alarming than we thought. So it's how do you see ever affecting enough change to affect that? And it comes from a place of deep sympathy and respect.
Yeah.
Oh my goodness.
I
No.
definitely understand the question, and it's
Oh, now, yes.
I think that honestly, I really feel that our case, it has brought a lot of these conversations to the forefront. Martha Nussbaum has written more extensively about like sort of the environmental side of things, and she also filed an amicus brief in our case. I would say, my background is environmental. So I went at my master's degree is environmental science and policy. Went to Vermont Law School where we specialize in environmental science. There's a lot of overlap between like biodiversity and species, preservation, and then animal rights, individual animals, not looking at Happy as just this big conglomerate of elephants, but as an individual being, just like one of us who was in prison. And so we're really not able right now to address like global habitat loss. But what I would say is that the awareness about elephants becoming their intelligence and their autonomy and their empathy, all of these sort of capabilities that they have are now being spotlighted. Our expert witness Joyce Poole is featured in a Natalie Portman narrated documentary series on I think it's on Nat Geo Discovery, maybe Disney Plus too. I don't know how that works, but it's in National Geographic, and our case is mentioned in the recent National Geographic. And I feel like they discuss habitat loss in the documentary in different ways where there's human elephant communities where there has been that loss, and how we can actually change that paradigm. So they are now growing different types of leaves that the elephants, like in different parts of Thailand or places where elephants haven't been able to roam. They're figuring out strategies. Once they're starting to understand how elephants work and getting real experts like Joyce Poole out there, they're able to work with communities and figure out solutions so that habitat loss doesn't continue at the rate it does, and so forth. I will say the answer is not captive breeding elephants. That is absolutely not the answer, and we'll probably roll out more stuff on that. But
yeah, absolutely. Liddy, did you want to add anything to Monica's very astute answer there?
No, I mean, her answer was spot on, perfect. And to me, when you shed the spotlight on an issue, on any issue dealing with animals, you're entering into a bigger conversation. And so I think, and especially if we're talking about the environment, if we're talking about species depletion, if when you start talking about elephants and great apes and cetaceans and what, as Monica said, their extraordinariness, you're getting into this bigger conversation of how do we protect them? Which then goes to how do you protect the environment? Because you can't do one without the other.
no.
And that's what I think, and we were talking about the legislature, the judiciary running on parallel tracks. These tracks intersect in so many places. And I think that by opening one conversation you're just necessarily going to open the other, and they're going to work together to in some way, because as Monica said, the answer is not captive breeding. The answer is not taking elephants from the wild and putting them in zoos, thinking you are protecting the species by doing that. Those are not the answers to species depletion and protecting the environment.
It's like it's like, you know, you wouldn't protect the human species vis-a-vis slavery. Like it's such a perverse way to address this. Now there might be ways to do some sort of breeding is not even the word I want to use, but a way to regenerate populations of elephants in their natural habitats that could be explored. But what zoos are doing in stateside is so contrary to the species that it can't be justified in captive breeding terms.
Mm-hmm. Yes, and I'll just add that what we're doing is challenging a mentality that the planet and animals are ours to use and abuse.
Mm-hmm.
And we invite people to think differently, envision a different sort of future there, and judges and otherwise. And so that's what we really have to change on the whole, that mindset, and the law helps us do that.
Oh, I love the way you just said that, Lauren. That gave me chills.
Me too.
That really gave me chills.
Well, I absorbed from you guys and then put it back out there. But yeah, and it's sort of too like that persistence, like we just have to keep trying. If we don't, it's all gonna be destroyed, you know? So we just have to keep trying and know what is right and keep bringing that before those in power and changing minds. And that's all we can do together. So I'm going to end on that note. There's more questions, and I think we can save these questions.
Yeah, let's do another one of these. I mean, I think it's really important if folks want to listen to what we have to say.
Yeah, absolutely. And I'm just going to, we have 2 minutes left, and I'm just going to give really quick rundown of where our clients are and just sort of the broad terms, how people can help.
Right.
Happy and Patty remain in captivity in the Bronx Zoo. Their spread of awareness about this bill. You can find it on our website. Just spread the word. That's the best thing to do right now. And if you're in New York, you can, you know, there'll be more for you to do soon. So stay tuned. For Hercules and Leo, like thankfully they're free of life as research subjects. They were transferred from the New Iberia Research Center, which owned them and leased them out, to Project Chimp Sanctuary. Good, which is good. They're a sanctuary accredited by NAPSA and things, but we have serious concerns about what sanctuary life is like for chimpanzees there. We've voiced them publicly and privately repeatedly over the years. Those concerns remain. It has to do with respect for their autonomy and giving them daily outdoor access, which they do not have. Project Chimps next month plans to announce that they're building out a new habitat. We're paying close attention to what they're going to do and say there. So stay tuned on that front. There may be more that others can do to help ensure that chimpanzees at Project Chimps have what they need to enjoy their autonomy the way they deserve. Let's see. Kiko sadly passed away in 2016 without the owner giving any public statement and continuing to fundraise off his image on social media, which is, there's that. And we didn't know it at the time. It took a while going through paperwork to figure out that he had died, because that's what happens when you're a rightless thing. You can just live and die with no one really knowing what your life is like and what happened to you, because animal welfare is not enough for that. Okay. Tommy, we believe, again, after lots of digging, hiring private investigators and other things, was transferred out of state to Michigan at a place called the DeYoung Family Zoo. It's not as charming as it might sound from the name. It's not a good place for chimpanzees. We have already invited our supporters to contact the zoo to urge them to acknowledge that Tommy is there and release him and the other chimpanzees to a sanctuary. And so we're gonna have more on that front as well. The fight is not over for any of our clients, whether in court or out of court. So broadly speaking, the best thing you can do is spread the word about all this happening and why it matters to you, why you want to see rights for animals. And then donate. Obviously, the more you donate, the more we can do. So
we make money go very far here.
We do. There's this. You're looking at like maybe a third of our whole staff here. So, yeah.
legal
and
team.
there are more protests planned at the Bronx Zoo. I see that question, so I'll sneak that in there. Thank you all so much for staying with us extra, and we'll attend to all the questions we didn't get to soon. We'll do more of these, and I didn't say I'm the communications director. I never introduced there you go.
Our wonderful communications director, who's been with
That's
us for
for
just as
sure.
long. I mean, she's been from the dawn of time too, so.
I have, yes, the dawn of time. Yes.
Dawn of timers.
Yeah, and to our supporters, thank you so much. Like, we are so appreciative of you. You help us keep going. Like, we love your messages that you send and love meeting you at protests and other
Yeah.
things. Please keep coming to this and everything.
Yes.
The conversations will continue. So I'm gonna end the meeting now, and we'll see you all soon, I hope. Okay.
Bye.
All right.
Thank you. Bye.